है।
Lifetime ban was evident in 2018 and onwards. No constitutional amendment ever chose to deal with this issue. Even though this was something, the disqualification of politicians or those running for a parliamentary office is something that affected Parliament directly. But nonetheless, the Parliament chose not to deal with it. So, my lord,
Could it be because एक वो उन्होंने लैंग्वेज चेंज कर दी थी वो ओथ में, तो पूरा पाकिस्तान को बंद कर दिया, तो हो सकता है उन्होंने कहा इसको छोड़ ही दें। ये भी तो हो सकता है ना, क्योंकि लोग जो बोलते हैं ना what word should be used for them who don't want to follow the legal or constitutional path but want to impose their will on the state. So, but the state is still cognizant of the fact that who will deal with these people.
My lord, if one could go back in time, one could want to change a lot of things. वो as Ghalib said जी, वो हर एक बात पे कहना कि यूं होता तो क्या होता, वो we don't know कि क्या होता. We are stuck with the letter of the law, right? What as it is, and we have to deal with that. Whether that is how it came about. So my lord,
हम आपसे सुनना चाहते हैं कि अब होगा तो कैसे होगा?
My lord, yes. I mean, I don't think a lifetime ban ought to be there, frankly, and I don't think the way I read it, Samiullah
Be there or should not be there?
Should not be there. It should not be there. But I have tried, and as will be evident from my submissions, to find a way out from on the basis of Samiullah Baloch, and I'll say that. My lord, and this fact that Parliament chose not to deal with this issue through the 18th Amendment is actually considered in Samiullah Baloch itself. Your lordships may just note paras 17 and 23. Para 17 at 432 and para 23 at 436. And it becomes actually very clear from para 9 of Justice Asma Said's separate note. Very clearly says that, well, this is what Parliament has done, and why are you asking us to change? And those of us, my lord, who knew Justice Asma Said in his personal capacity knew that there is a touch of exasperation in what he's written in para 9. So this is the key. My lord, my submission is, what has Samiullah Baloch actually done? It has interpreted these words, and my lord the Chief Justice asked this question, what do these words mean? There being no declaration to the contrary by a court of law. What Samiullah Baloch has done is that it has linked the disqualification to the declaration by the court, and extrapolated from that since the basis of the disqualification or lack of qualification is the declaration by the court, therefore it should be coterminous with the decree itself, the declaration by the court itself. So long as the decree continues, the judgment continues, the disqualification continues. So if there is some way to end the effect of the decree, the disqualification will also end. That's the logical consequence. Samiullah Baloch in para 35 alludes to this, touches upon this, but then doesn't really go on and explain this. So, my lord, so I will come back to this, but one point, as I said, your lordships are sitting in a larger bench. Your lordships can obviously revisit Samiullah Baloch. Should it be revisited? My lord, the argument for its overruling or revisiting it is weighty. I don't dispute that. But in my humble opinion, even without overruling Samiullah Baloch, a way out can be found. And why do I say that, my lord? Why do I say that Samiullah Baloch should not be overruled? My lord, the prime argument that I am aware of, and I heard bits and pieces during the live broadcast a day ago, was that 62.1F should be read along with 63.1H. And reading them, this seems to be the main argument. This argument was considered in Samiullah Baloch in great detail in paras 27 to 32, pages 438 to 442. And they said that it was held that these two are separate. Qualifications and disqualifications are separate, and we can't use them. an expression that I have used earlier also before, my lord, is that in my view they are like Siamese twins. Siamese twins are joined at the hip, so they are one for many purposes, but actually they are two separate persons, two separate entities. So they are separate for some purposes and they are joint for some purposes. For example, Your Lordship, the Article 100 of the Constitution talks about the qualifications for the Attorney General. And those have been interpreted, Article 100 has been interpreted to mean that only the qualifications given in Article 62 shall apply, or for the qualifications required of a judge of the Supreme Court in that case will apply, and not the disqualifications. My lord, in Rafiq Tarad's case, PLD 1998, Lahore 461.
PLD 1998
Lahore 461. It was a full bench decision of the Lahore High Court. Just note, I'm not, there the question was that Article 41 says the President has to have the qualifications for same qualifications as Member of Parliament. And the question was whether the disqualifications mentioned in Article 63 will also be applicable. And it was held by the full bench that because the word qualifications is used, only Article 62 will apply and Article 63 will not apply. So there is a conceptual difference between the two, but for certain matters they have to be read together, but not always. So my lord, my submission is that this argument that 62(1)(f) should be read together with 63(1)(h) and draw its inspiration in terms of the duration from 63(1)(h) was considered and was not accepted. Since it relied on earlier judgments starting from the 1960s, hence, since it has been there for a long time, there are many precedents for it. Therefore, in my humble opinion, it should not be overruled. My lord, I'll just place 2-3 judgments on that before you.
आप हमें अपना बता देना.
जी, मैं तो अपना बता रहा हूँ.
When you say it should not be overruled, we observe number of judgments have been cited, including Faisal Wawda, same learned judge, not following Samiullah Baloch.
My lord, I will. When I come to this way out, I will rely on Faisal Wawda. I think it is consistent. It explains.
How do you reconcile the two?
My lord, they will be reconciled. They are not.
Can you reconcile the two?
My lord, I will make submission on that. I think.
कर देना.
मैं वो तो आखिरी पॉइंट.
नहीं आखिरी नहीं, देखिए हमें थोड़ा सा स्पीड अप करना.
आप पहले. My lord, वो फिर मैं अपने नोट्स के आखिरी पेज.
नहीं आप आ जाएं.
My lord,
को हमें और लोगों को भी सुनना है ना.
नहीं मैं बिल्कुल जी, मुझे तो खुद.
आप लाहौर नहीं जा सकेंगे.
सर मैं आज लाहौर में गया तो जी मैं लाहौर शायद कभी भी नहीं जा सकूंगा.
ये भी हो सकता है.
So इसलिए मुझे प्लीज आज जाना.
Let me try another way. Motorway closes at 3:30. Motorway closes at 3:30.
चले जल्दी बताए ना.
My lord, I'll finish in 20 minutes.
चले.
My lord, for me, the key to this issue, and I'm now sort of jumping to the last page of my argument. My lord, the key to this issue.
अगर आपने लिखा हुआ है वो हम पढ़ लेंगे.
My lord, वो मैंने अपने लिए मैं आपको दे दूंगा. मैं एक आध दिन में आपको भैया तो मैंने गाड़ी में कल टाइप किया जी, बहुत टाइम नहीं था मेरे पास. My lord, the key for me to resolving this issue really is in para 6 of Samiullah Baloch.
जी पढ़े.
A point which was put before the court, but then the court.
तौबा कॉन्सेप्ट. हाँ वो डिस्कस किया, आगे जवाब नहीं उसका.
नहीं है वो, इसलिए कि उन्होंने कह दिया. And what they have said there, the reason they did not consider it, my lord, is also significant. He was, however, candid to accept, and there the court is dealing with Sadar Aslam's submissions here. He was, however, candid to accept that except for submitting their affidavits in court, his clients had not made any expression of remorse, regret or repentance before the concerned authorities or the public. And the question arises, what would have happened if that had been done? The way out, as I see it, and which something Samiullah Baloch doesn't deal with, is exactly because of this, that if this is established, that there is genuine repentance, there is, and penance has been paid, then the effect of the declaration can come to an end. And
then again we are reading words into the constitution.
My lord, that is something, my lord, it's a question of interpretation. It is the question of interpretation. And my lord,
I earlier posed a question. If I was the author of Imagine, it's not been written yet, Samiullah Baloch, and I'm hearing it for the first time, and I said it should be a 2-year ban. So it's entirely up to me what I do.
Lord, I'm not saying that there should be a fixed plan. That's exactly what I'm saying.
I'm just saying what is the test before me? It's not because Samiullah Baloch has held this. That's the end of story.
No,
there must be a logical reasoning behind it, reaching that conclusion. So I'm saying if I was author, I say, if that is 5 years, I do 5 years. Or I say that is much more serious, I do 2 years. So it's entirely my discretion. Unguided by any legal concept or constitution.
I'm not in favor of that at all. I'm not advocating that.
So it would be as valid a judgment as Samiullah Baloch.
No, my lord. I'm not saying that. I am not saying that. I am not saying that the judges should have a carte blanche to write whatever they want. Whatever they write has to be...
Guiding principle बताइए ना हमें.
So Mr. Uzair, your principle is that one principle or way out is that if there is a declaration, it could be washed away through penance and repentance immediately, whenever given. So if the declaration is given today, in 1 hour I submit an affidavit of repentance, the matter comes to an end, or is there a time frame?
No, my lord.
How would that work?
As they say, my lord, the devil is always in the details. My lord, 62(1)(f encapsulates 5 different concepts. Like, for example, there is a requirement that the candidate be non-profligate. Now, profligacy, the simple meaning is, spendthrift. You wasteful of resources.
Yes.
No.
Now, that's something that's probably easier to fix.
Suppose the declaration is that there was a misdeclaration in a form which has left the declaration, then there is no direct declaration in any case. We're assuming that the declaration is that you're not honest because you're... So, next day he comes and says, I'm very sorry, this will never happen again, sir. I'll never misdeclare ever. And he's repented. What else would you want him to do?
My lord, because the first, I don't agree with what your lordship has said in the first part of your statement. The fact that there is a form and there is something wrong with that is not enough. That is not enough to disqualify him.
That's happening in all these cases.
No.
There is no declaration. The declaration is based on a construction. It says that the form is incorrect, the assets form is not incorrect, you've left out this paragraph, you've done this, that's all there is that they discover. And then they build it on that. They say, because this is omitted, you are not a mean. That's the declaration in every case.
But we are, your lordships and your ladyship are here precisely to see whether that's right or not.
No, so that's a separate...
That's not
here to see, but to
that's
be
not
assisted by you.
Mr. Uzair, that's a separate basket of questions here. Then whether at all in any of these cases so far till date, is there a declaration looking straight into your eyes saying you're not honest because of the following issues? No, it's not. Nobody's saying that. One is just building, and that's what Samiullah Baloch also says. You'll have to construe from the facts, and you say that you're not honest.
My lord, इसीलिए मैंने कहा था कि वो आप मुझे page 6 पे ले गए मेरे notes के. If I had gone through pages 2, 3, and 4, maybe I would have been able to make some submissions on that. My lord, I am very clear that merely because somebody finds that I haven't dotted all I's and crossed all T's in my nomination form, I am dishonest. I am not saying that is correct. That's wrong. That's wrong.
Then in that case, Mr. Uzair, there is no declaration ever so far in any case.
But the point is, what is the declaration to the contrary by a court of law that 62(1)(f) contemplates? Where does that come from? And that's, I will make some submissions on that. For me, that's a formal process that has to be followed. It's not something that the RO can do. It's not something that the election tribunal hearing appeals against acceptance and rejection of nomination papers.
Or a constitutional court.
Constitutional court can do it. There is your lordship's judgment in 2010.
There could be mistakes made, but the question is,
that is not a mistake. That's a conscious judgment by my lord, and I rely on it. And that's absolutely correct.
I'm not noting anything.
My lord, so what I'm saying is, my lord, my submission was that for me the way out is provided by the logic, the rationale of Samiullah Baloch itself. Samiullah Baloch is deficient because it doesn't follow through with the consequences of its own logic. For example, so that's the problem. And if that gap can be filled, then there is no need to overrule Samiullah Baloch. Samiullah Baloch is a judgment
on that point, That's why you want to take it forward. You said the Samiullah Baloch gives an answer in paragraph 6 that there should be repentance, but it doesn't talk about it.
It touches
And
upon
I asked you that how do we follow through? Then you say, no, there is no declaration. So please tell us, the declaration is just the way it is. When does the repentance kick in and how do you bring that in?
There are two stages. First, there will be a declaration by a court. There will be a declaration by the court, and that declaration would be for the purposes of 62(1)(f). One problem with Samiullah Baloch is that it doesn't really deal with what court, what proceedings, what nature of dispute would lead to this declaration.
Mr. Bhandari, in paragraph 36 of the Samiullah, there is a word